Hello all, welcome to EPG Pathshala. I am Dr. Anand Raut and we are going to discuss access to legal aid and video conferencing. Access to legal aid is a right and video conferencing is an advancement in science and technology. We will discuss both of them in relation to correctional administration and prisoners and under trials. Speaking about prisoners or under trials, it needs to be understood that they are human and by mere virtue of being human entitles them with certain natural and fundamental human rights. International human rights conventions like Universal Declaration of Human Rights 1948 states that everyone has the right to recognition everywhere as a person before law, thus signifying that prisoner does not cease to be person even if he is in prison. European Convention on Human Rights and Charter of Fundamental Rights of the European Union also voices for the protection of human rights of prisoners. Judiciary in India has recognized political, cultural and other rights of the prisoners. One of such many rights is right of access to legal aid. Before delving deep into the scope and application of right of access to legal aid, let's discuss the meaning of term legal aid. Legal aid is umbrella term and includes within itself many rights such as right to counsel, right to fair trial, right to legal assistance, etc. Legal aid is providing assistance to people who are otherwise unable to afford legal representation and access to court system. The purpose of legal aid is to inform those who are in contact with law the extent of their rights and provide assurance of the existence and availability of the services irrespective of social and economic means. Progressive countries in the world have made provisions for legal aid. For example, there exists a network of community legal aid centers in Australia. New Zealand funds for those who cannot afford legal counsel. England and Wales has Legal Aid and Advice Act 1949. Let's have a glance at legal aid in India. Constitution of India 1950 recognizes providing legal aid as one of the directive principles of state policy. Article 39A of Indian Constitution provides for equal justice and free legal aid. It further states that state shall secure that the operation of legal system promotes justice on basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Order 33, Rule 18 of the Code of Civil Procedure 1908 provides that state and central governments may make supplementary provisions as it thinks fit for providing free legal services to those who have been permitted to sue as an indigent person. Legal Services Authorities Act 1987 was enacted to constitute legal services authorities for providing free and competent legal services to weaker sections of the society to ensure that opportunities for securing justice were not denied to any citizen by reason of economic or other disabilities and to organize. Section 2, Clause 1, Subclause A of the Act states that legal aid can be provided to a person for a case which includes a suit or any proceeding before a court. Under trials in prisons, thus may get benefited against whom case is pending. In Sukhdas versus Union Territory of Arunachal Pradesh 1986 case, it was held that legal needs of poor and illiterate are crisis oriented and they ought to be provided legal aid. Let us now discuss legal aid to under trials and prisoners. Indian judiciary has recognized right of access to legal aid to prisoners. In M.H. Hoscott versus State of Maharashtra, Honorable Supreme Court held that where the prisoner is disabled from engaging a lawyer on reasonable grounds such as indigence, the court shall, if the circumstances of the court, the gravity of the sentence and the ends of justice so require, assign competent counsel for the prisoner's defense, provided the party does not object to that lawyer. It is also stated that state which prosecuted the prisoner and set in the motion the process which deprived him of his liberty shall pay to the assigned counsel such sum as the court may equitably fix. In another landmark case of Francis Caroli Mullin versus Union Territory of Delhi 1981, it was held that detainee had right to consult legal advisor of his choice. In Sukhdas versus Union Territory of Arunachal Pradesh, it was held that legal needs of poor and illiterate are crisis oriented and they ought to be provided legal aid. In another famous case of Sunil Batra versus Delhi Administration 1980, Honorable Supreme Court of India recognized right of prisoners legal aid not only in judicial proceedings but also proceedings conducted by jail authorities which are administrative in nature. In Khatri versus State of Bihar 1981 case, it was held that the state is under constitutional mandate to provide free legal aid to accused person who is unable to secure legal services due to indigence. Similarly, in Hussain Ara Khatun versus State of Bihar 1979, Honorable Supreme Court has stated that right to legal aid is an essential ingredient of reasonable, fair and just procedure to a prisoner who is to seek his liberation through the court's process, that he should have legal services available to him. Free legal service to poor and the needy is an essential element of any reasonable, fair and just procedure. This was the scope and meaning of access to legal aid. Before discussing video conferencing, let us have a look at use of science and technology in law. Science and technology has played a significant role in the realm of law. It has aided law and administration of justice. For example, deception detection techniques like polygraph, narcoanalysis, brain mapping are used to collect information from those accused or suspects who try to conceal it. Speed guns are used to catch vehicles exceeding speed limits. Breath analyzers are used to detect percentage of alcohol in body to prevent offense of drink and driving. Forensic science and tools are used to collect evidence and detect crime. Video conferencing is such another advancement in information communication technology. So, the question is, what is video conferencing? The answer is, video conferencing is real-time, ideally fully interactive, face-to-face communication that permits physically separated persons to meet virtually as if they are in the same physical space. Such virtual meetings can be achieved using a range of video conferencing technologies. Before discussing legality of video conferencing and its other related aspects, we will discuss what are the merits and demerits of video conferencing. While discussing about the merits of video conferencing provides an alternative to the conventional practice of in-person, a witness trial, and hence following are the merits of video conferencing. Number 1, a witness or under trial or prisoner may be transmitted directly to courtroom irrespective of his physical location. This facility may provide solution to many problems. Sometimes it might happen that the prisoner or the person who is to be produced in the courts of law is at different geographic location, and thus video conferencing offers solution to geographical restrictions. Number 2, at times safety of the witness is vulnerable. In terms of his safety and security, it might be a huge risk to the life of witness or prisoner who is to be presented in the courts of law. In such situations, video conferencing will allow him to testify from prison. This provides solution to security concerns in transporting a prisoner from prison to court. Number 3rd merit is not only security issues but the cost and time involved in transporting the witness or prisoner can be tremendous, but video conferencing is comparatively safe, time friendly and less costly. It enables to testify witness or under trial residing even in a foreign country, especially in those cases which are international in nature and it is not feasible to frequently call the witness to testify. These advantages saves delays in delivery of justice. Well, having discussed advantages of video conferencing in the administration of justice, it is imperative to understand difficulties or issues in its implementation, that is demerits. First demerit is poor audio or video clarity which may hinder the conduct of trial. Second is disturbances in network connection which may hamper entire communication, causing unreasonable delay in trial. Third is absence of expertise who takes care of technicalities, which might be another impediment in the trial, and dependence on human sources might increase costs in conducting video conferencing. Fourth demerit may be the constraints of number of people who may participate in video conference, which may again limit the number of persons who may be made part of trial, as only few number of persons can participate simultaneously in video conference. The fifth demerit of video conferencing might be to examine its extent of legality. The legality of video conferencing as law should recognize validity of video conferencing only then it may be a part of court proceeding. Video conferencing should receive legal recognition, so it may be conducted in the courts of law. Video conferencing with a prisoner for the purposes of his trial may work to the greatest advantage of judicial system, and it may be very much beneficial to law enforcement agencies. But it is to be understood that whether such recordings made through video conferencing are legally admissible as evidence in the courts of law or not. Especially when it comes to India, we need to examine the legality of video conferencing as evidence in the courts of law. Hence, it is necessary to understand the scope of evidence first as per Indian law. Evidence as per section 3 of Indian Evidence Act 1872 means and includes all statements which the court permits or requires to be made before it by the witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Then all documents including electronic records produced for the inspection of the court, such documents are called documentary evidence, and anything that has to recognized as evidence must comply with section 3 of the Indian Evidence Act 1872, and therefore it is imperative to examine whether recording through video conferencing complies with section 3 of Indian Evidence Act or not. Section 3 speaks of oral evidence and documentary evidence. Section 3 recognizes electronic record as evidence, and video conferencing being an electronic record may be recognized as evidence under Indian evidence law. Section 65 of Indian Evidence Act 1872, hereinafter we will refer it as Evidence Act, says that the contents of electronic record may be proved in accordance with the provisions of section 65 of the Evidence Act. Thus, video conferencing is valid evidence in law if it is satisfies contents of section 65B. Section 65B of the Evidence Act says that any information contained in electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the condition mentioned in section 65B are satisfied in relation to information and computer in question and shall be admissible in any proceedings without further proof or production of the original as the evidence of any contents of the original or of any fact stated therein of which direct evidence would be admissible. Thus, it may very well be said that video conferencing satisfies with the condition mentioned in section 65B of the Indian Evidence Act. Video conferencing may involve oral admissions also. That means, oral admissions may be through video conferencing. It is pertinent to note that section 22A of Evidence Act speaks about relevancy of oral admissions as to contents of electronic records. As per this section, recording through video conferencing shall not be considered relevant unless the genuineness of electronic record produced is in question. Further, section 45A of the Evidence Act, which speaks about opinion of examiner of electronic evidence, is relevant for video conferencing, as the section states that when in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of examiner of electronic evidence referred to in section 79A of the Information Technology Act 2000 is a relevant fact. Let us now analyze judicial view on video conferencing and laws regulating it in India. Judiciary in number of cases has recognized legal validity of video conferencing and thus has set a precedent in this regard. One of the prominent cases in which video conferencing was allowed and was held valid was the case of Amitabh Bagchi and Ina Bagchi. The validity of video conferencing in India is significant because once video conferencing is regarded as legally valid or as legally admissible in the courts of law, it can be used as a tool to provide access to legal aid. Let us now see what was the court's judgment or its decision in Ina Bagchi's case. The case was a matrimonial dispute in which a wife had claimed alimony and litigation expenses. In this case, the court was asked to dispose of the matter within 2 months from the date of communication of the order without granting any unnecessary adjournment. The husband was residing in United States of America and it would have involved a great deal of hardship, inconvenience for the husband to remain present in India for trial. On his application, Honorable High Court allowed him to adduce evidence and it stated that physical presence of a person may not be required for the purpose of adducing evidence. Evidence includes video conferencing. This judgment put all the claims to the rest which were raised on the issue of legality of video conferencing. Honorable High Court went on to state that video conferencing is an advancement of science and technology which permits one to see, hear and talk with someone far away with the same facility and ease as if he is present herein. The only difference is that one cannot touch the person concerned. Even then, it will not disentitle a person to give evidence in such a way because of various reasons which the court considered. The court further stated that the essential requirement of advancement of technology and its application is to make things easier and flexible. The court is meant for the people, so it is required for the court to give reasonable and appropriate facility to the people. it also recognized video conferencing as a facility aiding to offer justice to people. Honorable Court laid down safeguards to be undertaken for the purpose of recording evidence through audio-video link. First safeguard is that before action of the witness under audio-video link starts, the witness will have to file an affidavit or an undertaking duly verified before a judge or a magistrate or a notary that the person who is shown as the witness is the same person as who is going to depose on the screen, with a copy of such identification affidavit to the other side. Now, this safeguard would help in the correct identification of witness. Now, let us see what was the second safeguard that was laid down by the court. Second safeguard is that the person who wishes to examine the witness on the screen will also file an affidavit or an undertaking in the similar manner before examining the witness, with a copy of the other side with regard to identification beforehand. By this safeguard, a duty was casted upon the person who wishes to examine witness through video conferencing. Third is, as soon as identification part is complete, oath will be administered through the media as per the Oaths Act 1969 of India. This fulfills the prerequisites of Oaths Act. And the fourth safeguard is, the witness will be examined during working hours of Indian courts. Plea of any inconvenience on account of time difference between India and other country will not be allowed. This safeguard ensured that court proceedings are not hampered due to differences of time zones. Now, let us see the fifth safeguard. Fifth safeguard is that the witness action, as far as practical, be proceeded without any interruption, without granting unnecessary adjournments. However, discretion of the court or the commissioner will be respected. These safeguards prove significant for curbing unnecessarily delays in proceedings. Now, let us see the sixth safeguard. Sixth is that the witness includes parties to the proceedings and court is empowered to put the condition or conditions necessary for the purpose. Similarly, several other safeguards were laid down. In another landmark case of the state of Maharashtra versus Dr. Praful B. Desai, a 2003 case, and this is a landmark case in this regard, Honorable Supreme Court recognized validity of video conferencing. This case was a case of medical negligence in which a doctor residing in a foreign country had to testify. An application for the video conferencing was made by the petitioner, and the same was challenged in the higher court by questioning its legality on following grounds. What were those grounds? Let us see. First, whether recording of evidence by video conferencing could be procedure established by law and non-violative of Article 14 and 21 of Indian Constitution, and number 2, whether Section 273 of Criminal Procedure Code provide for taking of evidence by video conferencing, and the term presence was also to be discussed. Section 273 may be interpreted to mean physical presence in flesh and blood in open court or not was also to be decided. Honorable Supreme Court observed that so long as the accused or his pleader are present when evidence is recorded by video conferencing, that evidence is being recorded in the presence of the accused and would thus fully meet the requirements of Section 273 of Criminal Procedure Code. Court also observed that recording of evidence by video conferencing also satisfies the object of providing in Section 273 that evidence be recorded in presence of accused. The court discussed following advantages of video conferencing in that case. Number 1. The accused and his pleader can see the witness as clearly as if witness was actually sitting before them. Number 2. It is in fact the accused may be able to see the witness better than he may have been able to if he was sitting in the dock in the crowded courtroom. Number 3. That demeanor can be properly observed. Number 4 advantage, deposition of the witness can be heard and reheard. Number 4th advantage, for the accused is able to instruct his pleader immediately, and thus cross-examination of the witness is as effective if not better. Number 5th is the facility of playback would give an added advantage while cross-examining the witness. Then let us see number 6th advantage. The witness can be confronted with the documents or other materials or statements in the same manner as if he or she was in court. Thus, video conferencing is legal in India. Validity and legality of video conferencing in India is very significant and crucial because it can be very well used as a tool or instrument for providing legal aid. Access to legal aid being recognized as fundamental human right in India, video conferencing's legality and its usage will be of great help in the administration of justice system in India. Let me remind you that not only in India, but there are various laws across the globe and there are various legal systems across the globe which recognizes video conferencing as an aid for providing access to legal aid. For example, Federal Magistrate Act 1999 and Crimes Act of Australia provides for video conferencing for witnesses or prisoners residing abroad. Federal Court Rules 1998 of Canada validates video conferencing for recording statements of witnesses or prisoners. Federal Rules of Criminal Procedure in United States of America allows hearing of witnesses through video conferencing for their first appearances. At the end, it may be summarized that video conferencing may be used as a tool in judicial process to cut down the delays and providing solution to demographic barriers for testifying witnesses. It may also help in curbing the harassment to prisoner and that medical aid is provided to them in case of need. This can happen because video conferencing will enable judges to visualize exact conditions in the prison. This system will also make prison administration more accountable and chances of corruption in prison will reduce. However, on the other hand side, certain skepticisms have also been raised against the use of video conferencing, as it may not allow the under trial or the prisoner to speak without fear. The reason being that at the time of conferencing, he will be surrounded by prison authorities. Despite the apprehensions surrounding video conferencing, it can be concluded that video conferencing can be used as a great tool or instrument for achieving the ends of providing the legal aid to the needy persons as mandated by the Constitution of India. Thank you very much.